In this lecture, let us discuss state machinery. And in state machinery, we will discuss state executive and state legislature. But let me take you back to the previous discussions we have had. When we discuss union executive, what did I tell you? Union executive consists of president, vice president, prime minister, council of ministers, and the attorney general for India. Clear? In a similar fashion, we have the state executive as well. State executive consists of governor, chief minister, council of ministers, and advocate general of a state. That means the same parliamentary structure that we follow at the center, the same structure we follow in the states as well. And when it comes to state legislature, what did we discuss in union legislature? Union legislature or Parliament of India consists of president, who is an integral part of executive as well as legislature. So parliament consists of president, Rajya Sabha, and Lok Sabha. In a similar fashion, we have the state legislature as well. State legislature consists of governor, legislative council, legislative assembly. But there are only few states in India which have legislative councils in place. Not all states have legislative council. That means although we have a bicameral legislature at the center, which means Rajya Sabha and Lok Sabha, we have bicameral legislature only in few states in India. And in all other states, we have a unicameral legislature, only legislative assembly. But there are few states which have both legislative council as well as legislative assembly. In this lecture, we will discuss all that you need to know regarding state machinery. First up, let's look at state executive. So when we look at state executive consists of a governor of a state, second, chief minister, third, council of ministers headed by the chief minister, and fourth, we have the advocate general of a state. And when it comes to state legislature, we have governor, who is an integral part of both executive as well as legislature. We have legislative council as well in some states, and we have legislative assembly. When it comes to state executive, governor, chief minister, council of ministers, and advocate general of a state. When it comes to chief minister, if you have understood completely the office of the prime minister, there is no reason why you can't understand the office of the chief minister. Because if you replace prime minister with the chief minister in a particular statement, for example, there is a statement given, and if you replace prime minister with the chief minister, the statement would be correct. If you replace council of ministers at the central level in a statement with council of ministers at the state level, the statement again is correct. Because the same parliamentary form of democracy that we follow at the central level, the same parliamentary democracy we follow in the states as well. For example, the prime minister is appointed by the president, the chief minister is appointed by the governor. But is president of India having a discretion in choosing a prime minister? We have discussed yes. That means normally the party which has won the election, the leader of that political party is appointed as the prime minister by the president. In a similar fashion, the leader of a political party which has won the election, the leader of this party is appointed as the chief minister by the governor, or group of political parties coming together to form the government. The leader of this group is appointed as the prime minister by the president. In a similar fashion, the leader of a group of political parties coming together to form the government, the leader of this group is appointed as the chief minister by the governor. Similarly, all the council of ministers are appointed by the president only on the advice of the prime minister. That means somebody who is not recommended as a minister by the prime minister cannot be appointed by the president. In a similar fashion, all these council of ministers are appointed by the governor only on the advice of the chief minister. Clear? When you look at council of ministers at the union level, we have discussed that there is the superset council of ministers, subset cabinet. We have ministers of state. We have ministers of state with independent charge. The same structure is what we follow in the states as well. So at the state level also, we have a cabinet minister. We have ministers of state. We have ministers of state with independent charge. Similarly, the chief minister and the council of ministers, they hold office during the pleasure of the governor. In a similar fashion, the prime minister and the council of ministers, they hold office during the pleasure of the president. That means at any point in time, a minister can be dismissed by the president, but only on the advice of the prime minister. That's something that we have discussed. In a similar fashion, the governor may dismiss a state minister only on the advice of the chief minister. And this is also where we come across one important concept, which is doctrine of collective responsibility. And what is this doctrine of collective responsibility? Prime minister and his council of ministers, they are accountable to, collectively responsible to Lok Sabha. In a similar fashion, chief minister and his council of ministers, they are collectively responsible to legislative assembly, the lower house of state legislature. That means council of ministers swim and sink together, which means prime minister, if he resigns, or if prime minister dies, that is the resignation and the death of the entire council of ministers. In a similar fashion, with the resignation of a chief minister or the death of a chief minister, that is the resignation and death of the entire council of ministers. What is the limit? How many ministers can be appointed at the central level by the president? For that, we have discussed that in 2003, 91st Constitutional Amendment Act was passed. The prime minister was Atal Bihari Vajpayee, and it is this constitutional amendment of 2003 which has fixed the number. That means the council of ministers, including the prime minister, shall not exceed 15% of Lok Sabha. That means how many ministers can be appointed by the president in this council of ministry? 15%, not more than 15% of the strength of Lok Sabha. In a similar fashion, this is the limit for a state council of ministers as well. That means council of ministers, including the chief minister, shall not exceed 15% of the legislative assembly. Long story short, if you have understood prime minister and council of ministers at the central level, there is no reason why you can't understand the chief minister and the state council of ministers. Whatever is true at the central level, that holds true at the state level as well. But when it comes to advocate general of a state, the position can be slightly compared with the position of the attorney general for India. Now, who is this attorney general for India? The first law officer of the country. It is his responsibility to defend the central government in the Supreme Court, in various high courts in this country. That means he is the legal advisor of the central government. In a similar fashion, there is a state government. This state government can be dragged to court by you or me, by another state. For example, one state is dragging another state to the Supreme Court, or for example, the state government is dragging the central government to the Supreme Court. For example, there are various state governments which drag the center to the Supreme Court because of Citizenship Amendment Act. Chhattisgarh government, for example, when NIA Act was amended, National Investigation Agency Act, it was amended in the year 2019. Chhattisgarh government said it is against federal principles. Chhattisgarh government dragged the central government to the Supreme Court. Who is going to represent Chhattisgarh government in the Supreme Court? Advocate General of a state. That means the position of the Advocate General of a state can be compared with the position of the Attorney General for India. But there are two exceptions here, or there are two departures here. There are two different things here. Which are these two different things? Number one, Attorney General for India, he has a special role when it comes to Article 143 of the Constitution. What is Article 143? Supreme Court is the advisor of the President of India. President can refer any matter to the Supreme Court, asking the views of the Supreme Court on this matter. For example, when in 2012, 122 2G licenses were cancelled by the Supreme Court, the President of India referred this matter back to the Supreme Court. Please tell us, or please advise us, how should we allocate spectrum? How should we sell spectrum? That means advisory jurisdiction. That means President may refer any matter to the Supreme Court, asking the views of the Supreme Court on this matter. That's what we call advisory jurisdiction. But governor of a state cannot send any matter to the Supreme Court and ask the views of the Supreme Court on this matter. That means there is advisory jurisdiction when it comes to the President of India. But governor does not have this advisory jurisdiction. That means governor cannot refer any matter to the Supreme Court, asking the views of the Supreme Court on this matter. That means Attorney General for India, he has a special role to play under Article 143 of the Constitution. That means when this advisory jurisdiction is heard by the Supreme Court, who is going to present the side of the central government? Who is going to argue in favor of the central government, Attorney General for India. But since such a provision does not exist for a governor, which means Advocate General of a state does not have this provision, does not have this role when it comes to advisory jurisdiction. That's difference number one. Difference number two. When we discuss Attorney General for India, I told you what are the qualifications. Who is qualified to be appointed as the Attorney General for India? Qualification: somebody who is eligible to be appointed as the judge of a Supreme Court. That person is eligible to be appointed as Attorney General for India, right? But when it comes to Advocate General of a state, who is qualified to be appointed as the Advocate General of a state? Somebody who is qualified to be appointed as the judge of a high court. That means when it comes to union executive, there we have president, vice president, prime minister, council of ministers, Attorney General for India. In a similar fashion, we have state executive as well. There's governor, but there is no vice governor or deputy governor. But we have the chief minister, we have the council of ministers, we have Advocate General of the state. Advocate General of the state can be compared to the Attorney General for India, but with two exceptions. Council of ministers at the state level can be compared with the council of ministers at the central level. Problem solved. Chief minister at the state level can be compared with the prime minister at the central level. Problem solved. But governor cannot be compared with the president. Governor, as we shall see, is slightly more powerful, and that is because of his discretionary powers. So when it comes to state executive, we don't have to discuss council of ministers and the chief minister separately, because whatever is true for the prime minister and the council of ministers, that holds true for council of ministers headed by the chief minister. Clear? When it comes to Attorney General for India, whatever is true for him, that is true for Advocate General of a state as well, but with two exceptions. Exception one is he should be eligible to be appointed as the judge of a high court. Second, he does not have a role to play when it comes to advisory jurisdiction, because governor cannot refer any matter to the Supreme Court asking the views of the Supreme Court on that matter. That's the exclusive power of the President of India under Article 143. President may refer any matter to the Supreme Court asking the views of the Supreme Court on that matter. In a similar fashion, Attorney General for India, he has the right of audience throughout the country. That means he can walk into Kerala High Court, and Kerala High Court cannot refuse to hear Attorney General for India. This power or prestige or privilege that is available to Attorney General for India, it's available for Advocate General of a state as well, but only for the courts within that state. Which means Advocate General of a state can walk into a district court, and the district court will have to hear him. He can walk into a high court, and the high court will have to hear him. That's the privilege available to Advocate General of a state. But governor, we will have to discuss in more detail, because governor's office cannot be compared to the office of the President of India. We say President enjoys only influence, but governor enjoys influence as well as power. But we will discuss governor separately in great detail. But park your thoughts on governor. Let's look at state legislature. And state legislature consists of governor, which we will discuss in great detail, legislative council, and legislative assembly. Now let us look at legislative assembly, and we can compare legislative assembly with Lok Sabha as well. How? We can safely say whatever is true for Lok Sabha is true for legislative assembly. How? How are the members of the Lok Sabha elected? Elections after every 5 years. The entire country is divided into territorial boundaries or constituencies, and only one candidate can be elected as the representative of a constituency. In a similar fashion, we have a legislative assembly. Normally, after every 5 years, after every election, the members are elected to legislative assembly, and these members are directly elected by the people of that state. That is what we call legislative assembly. Normal term of Lok Sabha is 5 years. Normal term of legislative assembly is 5 years. The term of Lok Sabha can be extended during national emergency, which we will discuss. The term of legislative assembly can also be extended during national emergency, which we will discuss. Lok Sabha can be dissolved. Legislative assembly can also be dissolved. Lok Sabha has a speaker. Legislative assembly also has a speaker. The speaker is elected by simple majority. The speaker here is elected by simple majority. Here we have a deputy speaker. Here also we have a deputy speaker. Here we have money bills. Here money bills can be introduced. Money bills, financial bills can only be introduced in Lok Sabha. Money bills, financial bills can only be introduced in legislative assembly. That means, long story short, whatever is true for Lok Sabha, that is true for legislative assembly as well. But what is the composition of Lok Sabha? As we have discussed, Lok Sabha has 550 as its maximum strength, but the current strength is 543. That means it is mentioned that for 543 seats or in 543 constituencies, election will take place. One candidate will get elected from each of these constituencies. So in Lok Sabha, we will have 543 directly elected representatives. But what is going to be the strength of legislative assembly? Constitution does not talk about it. Constitution does not talk about what is the composition of legislative assembly. But Constitution talks about a range. And what is that range? Minimum members in a legislative assembly has to be 60, and the maximum it can go up to is 500. That means Constitution does not fix the composition, the strength of legislative assembly. Constitution only prescribes a range, and the range is minimum 60 MLAs should be there in a legislative assembly, and the maximum number of MLAs that can be there in a legislative assembly is 500. But here again, there are some exceptions. For Mizoram, we have only 40 MLAs in a legislative assembly. Similarly, for Goa, we have 40 MLAs in a legislative assembly. You will have to correct your Lakshmikant book, because Lakshmikant book says in Nagaland, in Arunachal Pradesh, we have 40 MLAs or 30 MLAs. That's not true. They have 60 MLAs in their legislative assembly. But long story short, in a legislative assembly, the minimum is fixed at 60, maximum it can go up to is 500. But there are a few states with exceptions. For example, Goa is an exception. It has only 40 MLAs. Mizoram is an exception. It has only 40 MLAs. But then something else. 104th Constitutional Amendment Act, the year was 2019. What happened? Prior to this constitutional amendment, one Anglo-Indian could have been nominated to a legislative assembly. I'll repeat. Prior to this amendment, one nominated MLA was there in all these legislative assemblies. If the governor is satisfied that an Anglo-Indian community member is not represented in the legislative assembly, there was this nominated category for him. That means one Anglo-Indian could have been nominated to legislative assembly from this Anglo-Indian community. But this 104th Constitutional Amendment Act 2019, it has ended the Anglo-Indian community reservation in legislative assemblies as well as in Lok Sabha. So now we don't have a nominated Anglo-Indian in the legislative assembly. This reservation has been ended. So what is legislative assembly? This is legislative assembly. The lower house of the state legislature can be compared with Lok Sabha, because Lok Sabha, after all, is also the lower house of Indian Parliament. Clear? How are MPs elected to Lok Sabha? In elections after every 5 years. How are MLAs elected to legislative assembly? Elections after every 5 years. Lok Sabha can be dissolved prematurely before completing 5 years. Similarly, legislative assembly can also be dissolved even before completing 5 years term. Clear? Who is qualified to contest elections to Lok Sabha? If you are a citizen of India, you have completed 25 years of age, you are eligible to contest election to Lok Sabha. In a similar fashion, who is eligible to contest election to legislative assembly? If you are a citizen of India, if you have completed 25 years of age. But so far as Lok Sabha is concerned, you should be a registered voter in any parliamentary constituency in this country to contest election to Lok Sabha. That means Rahul Gandhi, he was a registered voter in Delhi, but he contested from Wayanad constituency, parliamentary constituency, Lok Sabha constituency in Kerala. How is that possible? It is possible because you are qualified to contest Lok Sabha election provided you are a citizen of India, you have completed 25 years of age, you are a registered voter in any parliamentary constituency of this country. But when it comes to legislative assembly, if you are a citizen of India, you have completed 25 years of age, and you are a registered voter in any assembly constituency of that state, then you can contest legislative assembly election to that state legislative assembly. So these are the qualifications. What are the disqualifications? Change in the nature of citizenship, disqualified. A judge insolvent, disqualified. Office of profit, disqualified. If you are convicted by a court of law, disqualified. If you are sent to a jail term, disqualified. That means all those disqualifications which apply in case of a Lok Sabha MP, same disqualifications apply in case of a member of legislative assembly as well. Anti-defection law. A member of Lok Sabha can be disqualified on the grounds of defection. A member of legislative assembly can also be disqualified on the grounds of defection. Which means, long story short, whatever is true for legislative assembly, that is true for Lok Sabha as well. How is budget passed? Same procedure. Similarly, no confidence motion, censure motion, privilege motion, all these motions which can be introduced in Lok Sabha, the same motions can be introduced only in legislative assembly as well. So we don't have to discuss legislative assembly separately because whatever is true for Lok Sabha, that is true for legislative assembly as well. A few things that we need to keep in mind: the Constitution does not talk about the composition of legislative assembly. It talks about a range, minimum 60, maximum 500. Although there are a few exceptions. Clear? Similarly, there is no Anglo-Indian reservation now, even in legislative assemblies. That Anglo-Indian reservation is gone thanks to 104th Constitutional Amendment Act 2019. Similarly, when it comes to legislative assembly, financial bill, all these confidence, no confidence, censure, adjournment motion, all these can be introduced only in Lok Sabha. All these can be introduced only in legislative assembly as well. So let's close this chapter of legislative assembly. We don't have to discuss it separately because whatever is true for Lok Sabha, that is true for legislative assembly. But now let's look at legislative council. Legislative council cannot be compared with Rajya Sabha. We say Rajya Sabha is the second chamber of Indian Parliament, but legislative council is not the second chamber. We call it a secondary chamber. And what is the difference? The difference is legislative council is basically inferior. And when it is inferior, why should we have legislative councils? Let me take you through what happened in Andhra Pradesh. Jagan Mohan Reddy, the chief minister of Andhra Pradesh, his government decided that let's abolish legislative council. But the state government cannot abolish a legislative council. Legislative councils can be created, can be abolished only by the Parliament of India. So when it comes to legislative council, there are a few things that we need to discuss. Number one, who can establish a legislative council? Who can abolish a legislative council? How legislative council can be established? How legislative council can be abolished? Why few states have legislative councils? Why others do not have legislative councils? What is the role played by legislative councils? If the role played is inferior, why should we have legislative councils in the first place? All this and much more we are going to discuss now. When it comes to legislative council, it was debated heavily in the Constituent Assembly as well. Constituent Assembly, which gave us the Constitution. There are debates going on in the Constituent Assembly about the shape, form, and character of our Constitution. When it comes to legislative council, there was heated debate as well. Should there be bicameral legislature in the states, such as what we follow at the central level? Ultimately, a compromise was reached. A final conclusion was made that we will leave it to the states. If the states want legislative council, they can have it. If the states do not want legislative council, let's not have legislative councils for them. So the Constitution has placed the onus of having a legislative council on the states. If you can afford another chamber of state legislature, please do that. If you cannot, there is no obligation on you. That means we can't have an obligation on every state that you should have a bicameral legislature. If a state is poor, it cannot afford another chamber. It cannot afford a legislative council. We should not force it. But the state is wealthy enough and they want to have a legislative council, let them have a legislative council. So it is on the states to decide whether you want to have a legislative council or you don't want to have a legislative council. How many states do we have right now where legislative council is present, where we have a bicameral state legislature? These states are Andhra, Telangana, Maharashtra, Bihar, Uttar Pradesh, Karnataka. These are the only 6 states in India where we have legislative councils. Jammu and Kashmir had a legislative council, but that was the legislative council under the Constitution of Jammu and Kashmir. Now, after the revocation of the special status on August 5 and 6, 2019, when Jammu and Kashmir Reorganization Act was passed, legislative council was also abolished for Jammu and Kashmir. So Jammu and Kashmir currently does not have a legislative council. These are the only states in India which have bicameral legislature, which have 2 legislative houses, legislative assembly and the legislative council. Under Article 168 of the Constitution, a state legislature can either have 1 or 2 houses, which means either only a legislative assembly or both legislative assembly as well as legislative council. Under Article 169 of the Constitution, Parliament of India has the power. That means who has the power? Parliament. What is this power? Parliament can either establish a legislative council in those states where it is not present, or abolish a legislative council in those states. That means who has the power to either establish a legislative council or abolish a legislative council. Under Article 169, it is the power available with the Parliament of India. But Parliament cannot act on its own. That's why I told you that Constituent Assembly said, let's give it to the states. If they want to have a legislative council, if they can afford a legislative council, let them have it. If they don't want to have a legislative council, why force them? So under Article 169, this power is given to the Parliament. Parliament can either establish a legislative council where it is not present, or abolish a legislative council where it is present. But Parliament cannot act on its own. For that, Legislative Assembly has to pass a resolution, either to abolish a legislative council where it is present, or establish a legislative council where it is not present. Let's say, for example, we have Punjab. In Punjab, we don't have a legislative council. What is the process of establishing a legislative council? Punjab Legislative Assembly will pass a resolution. And what this resolution will do? This resolution will request the Parliament of India that please establish a legislative council in Punjab. What is the process? Under Article 169, it is the power of the Parliament to either establish a legislative council where it is not present or abolish a legislative council where it is present. But what is the procedure that needs to be followed? Punjab, for example, does not have a legislative council. Punjab Legislative Assembly will pass a resolution. And this resolution should be passed by special majority. And what is the special majority? 2/3 of the members present and voting plus absolute majority. That means majority of the 2/3 of the members present and voting and majority of the total membership of the House. If Punjab Legislative Assembly passes this resolution by special majority, it will request the Parliament, please establish legislative council for Punjab. Similarly, we have Andhra Pradesh. Andhra Pradesh Legislative Assembly will pass a resolution by special majority requesting the Parliament, please abolish legislative council for Andhra Pradesh. That means this process has to be initiated by the state legislative assembly. You pass a resolution by special majority, request the Parliament to either establish a legislative council or abolish a legislative council. One important thing here is, this resolution is not binding on the Parliament, which means Parliament may or may not accept this resolution. Punjab Legislative Assembly passing a resolution by special majority requesting the Parliament, please establish a legislative council. This resolution is not binding on the Parliament. Parliament may or may not establish legislative council for Punjab. Andhra Pradesh Legislative Assembly passing a resolution by special majority requesting the Parliament, please abolish legislative council for Andhra Pradesh. This resolution is not binding on the Parliament. Parliament may or may not abolish legislative council for Andhra Pradesh. But this is the process that needs to be followed. Let's say, for example, Parliament accepts the resolution of Punjab. And what Parliament will do? Parliament will pass a law and establish legislative council for Punjab. And this law will be passed by simple majority. Similarly, for Andhra Pradesh, Parliament may by law pass a law by simple majority and abolish legislative council for Andhra Pradesh by a simple majority. And this is where one more important concept comes into picture. Constitution talks about legislative assembly, legislative council. Constitution also talks about that Andhra Pradesh, Telangana, Maharashtra, Bihar, Karnataka, Uttar Pradesh have legislative council, right? If tomorrow Punjab is also added to this list, clear? Andhra Pradesh is removed from this list. Are we not amending the constitution? If we are amending the constitution, but amendment to the constitution requires Article 368 requires special majority. Then how can Parliament by law, that too by simple majority, create a legislative council or abolish a legislative council? It is because when Parliament passes such a law, this law shall not be deemed as amendment to the constitution. And when this law is not deemed as amendment to the constitution, that means although you are amending the constitution, you are adding the word Punjab, you are removing the word Andhra Pradesh, but this is not amendment to the constitution, which means you can pass this law by simple majority. Just like what we discussed in Article 3. When a law is passed under Article 3, there will be changes in Schedule 1 and Schedule 4. But these changes shall not be deemed amendment to the constitution. That means although you are changing Schedule 1 and Schedule 4, but that is not amendment to the constitution. In a similar fashion, constitution has said, if you are abolishing a legislative council for a state, if you are establishing a legislative council for a state, it won't be deemed as amendment to the constitution. That means Parliament will pass a law by simple majority and make these changes. Long story short, not all states have legislative councils. These are the states which have legislative councils. Because constitution is left to the states. If you want, you can have. If you don't want, nobody is going to force you. But this legislative council, how it can be established and abolished? Parliament has the power. But Parliament cannot act on its own. Article 169 says, if the legislative assembly of a state passes a resolution by special majority, requesting the Parliament to either establish a council or abolish a council, Parliament may establish or abolish a council. And when Parliament is establishing or abolishing a legislative council, this law shall not be deemed as amendment to the Constitution under Article 368 of the Constitution of India. But now there's another question. What is the composition of legislative council? As I told you, for a legislative assembly, Constitution has not prescribed a number, a fixed number. Constitution has prescribed a range. Minimum 60, maximum it can go up to is 500. In a similar fashion, Constitution has not defined the composition of a legislative council. Constitution has prescribed a range. And what is that range? Minimum MLCs, members of legislative council, minimum should be 40, and maximum it can go up to is 1/3 of the strength of legislative assembly. That means what is the range that has been prescribed for a legislative council? Minimum it can have 40 MLCs, maximum it can go up to is 1/3 of the strength of legislative assembly. Who can be elected to this legislative council? This is where we see something unique. When we say Rajya Sabha and legislative council cannot be compared to each other, but who all can be elected or nominated to legislative council? Here's an interesting question. Can we compare legislative council with Rajya Sabha? No. Rajya Sabha is the second chamber of Indian Parliament. Legislative council is the secondary chamber or inferior chamber of the state legislature. How? Let's try and address these concerns. In Rajya Sabha, we have two sets of members elected from the states and union territories. Because in Rajya Sabha, we have representatives from the Union Territory of Delhi, Union Territory of Puducherry, Union Territory of Jammu and Kashmir as well. So in Rajya Sabha, we have elected members elected from the states and 3 union territories. In Rajya Sabha, we have nominated members as well, nominated by the president from the fields of art, literature, science, social service. In legislative council, if you are above the age of 30, you are eligible to become a member of legislative council, just like Rajya Sabha. Because for legislative assembly, if you are 25 years of age or above, you can contest Lok Sabha election, you can contest legislative assembly election. Similarly, if you are 30 years or above, you can be a member of Rajya Sabha. Similarly, if you are 30 years or above, you can be a member of legislative council. But the legislative council, its composition is different from that of Rajya Sabha. How? If this is legislative council, 1/3 of the members of legislative council, they will be elected by state legislative assemblies. Let's say, for example, in Maharashtra, we have a legislative council, right? Uddhav Thackeray, the chief minister of Maharashtra, is a member of legislative council. This means just like at the central level, prime minister can be either from Lok Sabha or Rajya Sabha. In a similar fashion, chief minister of a state can be either from legislative assembly or legislative council. If you are neither a member of legislative council nor a member of legislative assembly, you can still be appointed as the chief minister. Just like if you are neither a member of Lok Sabha nor Rajya Sabha, you can still be appointed as the prime minister. You can still be appointed as a minister. But within 6 months, you have to be elected to either Lok Sabha or Rajya Sabha. In a similar fashion, a minister can be appointed at the state level even if he or she is neither a member of legislative assembly nor a member of legislative council. But within 6 months, he or she has to get herself elected to either legislative assembly or legislative council. Uddhav Thackeray, he was neither a member of legislative assembly nor legislative council. He was still appointed as the chief minister of Maharashtra. Later on, within 6 months, he got himself elected to legislative council and he continued to be the chief minister of Maharashtra. Although there was a controversy then because of COVID-19 pandemic, legislative council elections could not take place or they were delayed, and the 6-month window was about to expire. So if Uddhav Thackeray could not get himself elected to legislative council within 6 months, he had no other option but to resign, and someone else would have been appointed as the chief minister, and he died. Prime Minister Modi. Ultimately, legislative council elections were held. He got himself elected to legislative council, and then he survived as the chief minister of Maharashtra. But here the point is, 1/3 of the members of legislative council, they are elected by the members of legislative assembly. So legislative assembly members, they vote and they elect 1/3 of members to legislative council. Just like legislative assembly members, MLAs, they vote and get MPs elected to Rajya Sabha. How are MPs to Rajya Sabha elected? MPs to Rajya Sabha are elected when MLAs, they vote and elect their representatives to Rajya Sabha. In a similar fashion, MLAs vote and get 1/3 of the members elected to legislative council. Same process is followed. Proportional representation system by means of single transferable vote. Just like what we see in Rajya Sabha elections, same process in legislative council elections as well. But there are other set of members as well. 1/3 of the members of legislative council, they are elected by the members of municipalities, district boards. So municipalities and district boards, their representatives, they elect 1/3 of the members to legislative council. Similarly, 1/12 are elected by graduates of 3 years standing. What do we mean by graduates of 3 years standing? All these graduates who have been graduates for 3 years in a particular state, they will form a constituency and they will elect 1/12 of the members to legislative council. Similarly, 1/12 of the members of legislative council will be elected by the teachers who are teaching for 3 years, that too not less than secondary school level. That means not less than 10th standard. All those teachers who are teaching within that state and they are teaching not less than 10 class students, they will form a constituency and they will get 1/12 of the MLCs elected to legislative council. And the remaining are nominated by the governor. Just like president nominates MPs to Rajya Sabha from the fields of arts, literature, science, social service, in a similar fashion, the governor of a state nominates 1/6 of the MLCs to legislative council from the fields of arts, literature, science. To make it even simpler for you, this is legislative council. In this legislative council, 1/3 members are elected by MLAs, members of legislative assembly. They vote and get them elected. 1/3 are elected by representatives of municipalities, district boards, local bodies. 1/12 are elected by teachers 1/12 are elected by graduates, 1/6 are nominated by the governor from the fields of art, literature, science, social service, cooperative service. And this is the composition of Legislative Council. And it is this composition which makes it unique and which makes it different from that of Rajya Sabha. Because Rajya Sabha has only two types of members, elected and nominated. Elected by the members of Legislative Assembly. But in Legislative Council, we have elected by MLAs, elected by local bodies, elected by teachers, elected by graduates, and then nominated by the governor. And just like Rajya Sabha, the term of an MLC, member of a Legislative Council, is 6 years to ensure that Legislative Council remains a permanent body. So just like Rajya Sabha, it's also a permanent House of State Legislature to ensure that 1/3 of the members, they retire every 2 years. And these members are eligible for re-election any number of times, just like Rajya Sabha MP. But now comes the big question, and this is something that you can expect in your mains question papers as well. Is it time to abolish these legislative councils? My answer would be yes. Because if you look at the composition of these legislative councils, unfortunately, legislative council is the retirement home of failed politicians. I'm a politician, I contested MLA election, I contested Lok Sabha election, I lost this election. But my party has to rehabilitate me. And how can my party rehabilitate me? By sending me to legislative council. And if party is rehabilitating me by sending me to legislative council, this legislative council becomes a retirement home for failed politicians. So if we have to rehabilitate somebody, send him to legislative council. And on top of that, I'm given salary, I'm given various perks, I have a bungalow, I have a car, I have my staff. It's an extra burden on extra burden on the state exchequer. And all these expenditures might be justified if I had a role to play. And when you look at this legislative process, the role of legislative council is very inferior. And its role is so inferior that it demands that it be abolished. It be dissolved once and for all. So no new legislative council should be created. And all these legislative councils which are in place should be abolished because we don't need them. And how can we surely say that we don't need these legislative councils? For that, we need to understand the legislative procedure. And after understanding this legislative procedure, you will also say we don't need these legislative councils because they are extra burden on the state exchequer. Instead, we can utilize this money to fund various social security schemes. We can use this money for the construction of roads, hospitals, for providing relief to flood victims, for providing relief to the victims of the COVID-19 pandemic. We don't need these legislative councils. How? Let's say, for example, we have legislative council, we have a legislative assembly, right? A bill. Bill is a proposal. This bill needs to be passed. How can we pass this bill? Lok Sabha passes this bill, Rajya Sabha passes this bill, President signs this bill becomes an act, it's the law of the land. In a bicameral legislature, this bill has to be passed by legislative assembly, legislative council, signed by the governor, then this bill becomes an act, the law of the land. Clear? Bill can originate in legislative council as well. Let's say, for example, the bill originates in legislative council, it is passed by legislative council, the bill is passed by legislative assembly as well. There is no problem here. The bill is then sent to the governor, governor signs this, the bill becomes an act, the law of the land. No problem here. Legislative council passes a bill. Legislative assembly rejects this bill. And what is the status of this bill? This bill is dead, it can never become a law. That means a proposal of a legislative council, if it is rejected by legislative assembly, that's the death of this bill will never become a law. Which means there is no procedure of a joint sitting of state legislatures. That means in case of a deadlock, what we see at the central level, if there's a deadlock on a particular bill between Lok Sabha and Rajya Sabha, to resolve this deadlock, what do we have? We have joint sitting of both the houses. There is no such concept at the state level. A bill originates in legislative council, is passed in legislative council, sent to legislative assembly. If legislative assembly passes this bill, no confusion at all, the bill is passed. If legislative assembly rejects this bill is dead, it can never become a law. Now let's look at the other picture. Now the originator is legislative assembly and the receiver is legislative council. Clear? And this is how we will come across the inferior role played by legislative council. And that is why it is my humble suggestion, let's abolish all these legislative councils wherever they are present. Legislative assembly passes a bill, legislative council also passes a bill. There is no confusion here, no controversy here, the bill is passed. Legislative assembly passes a bill. Now there are various other permutations and combinations involved. There are various options that are available to legislative council. Option number 1 is legislative council passes this bill. Then there is no confusion, no controversy. Second option is legislative council rejects a bill. Can happen. Legislative council amends a bill. It can also happen. Legislative council does not act on this bill. It can also happen. That means there are 4 combinations possible, 4 options available. Legislative council passing a bill, no controversy, rejects a bill, amends a bill, does not act on this bill. In all these 3 cases, this bill goes back to legislative assembly. You have rejected my bill, give us back. You have amended our bill, give us back. You have not acted on this bill, after some time, give us back. When this bill, which was rejected by legislative council, if legislative assembly again passes this bill, what will happen? This bill goes back to legislative council. Legislative council has all these options again. If it accepts this bill, no problem, the bill is passed. If it rejects this bill again, this bill is still passed. That means it doesn't matter why you are rejecting this bill, we have rejected it once, but we can't give you the power to reject this bill the second time. Despite your rejection, the bill is passed, it can become the law of the land. Why should we have legislative council then? When it can reject a bill only once and if the same bill is presented to it again, it has no role to play whatsoever. Legislative council amends this bill goes back to legislative assembly. Legislative assembly is very arrogant again. Arrogant as well. You amended our bill, we are going to pass the same bill again without amendments. Now do whatever you have to do. Legislative council says, okay, you're showing us attitude, I'm going to amend this bill again. Legislative council amends this bill again. Even with these amendments, the bill is passed. That means it doesn't matter why you're amending it. Your amendments have no value. The bill is passed in the form, in the manner it was passed by legislative assembly. That means what is the final shape of the bill? The final shape of the bill is the final shape given by legislative assembly. Why should we have legislative council then? Or legislative council does not act on this bill. After the expiry of 3 months, that means legislative assembly was waiting for 3 months. They are not acting on this bill. 3 months are over. This bill is brought back to legislative assembly. Legislative assembly again very arrogant, passes the bill again. And now the bill is sent to legislative council. Legislative council says, I'm not going to act on this bill again. Okay, that's another option. That means when this bill is sent back, what will happen? In this case, either legislative council will accept this bill. No problem. If it rejects this bill, even then the bill is passed, and the form in which it was passed by legislative assembly, the same form, the bill will be passed. It can also amend this bill. But these amendments will not matter. They are not valued at all. In the manner and form it was passed by legislative assembly, the bill is passed. And if the legislative council does not act on this bill again, at the expiry of 1 month period, the bill shall be deemed to be passed by the state legislature, which means the maximum that a legislative council can do. It can delay the passage of a bill by 4 months. And for this reason, why should we have legislative councils in the first place? That means it is this inferior legislative process that tells us quite loudly and clearly that there should be no space, no place for legislative councils in India. That is why Andhra Pradesh is right. That is why Jagan Mohan Reddy is right in recommending that legislative council in Andhra Pradesh should be abolished. And it is high time that it be abolished in all the states in India. Legislative council is unique in the sense that it is represented by different sections of the society. Teachers, graduates, representatives of the municipalities, the local bodies, the elected MLAs also elect members to legislative council. Governor has some nominations, but if the legislative role of council is so poor, we don't need a legislative council in India. That means now we have come to a point where we have discussed state executive. State executive consists of governor, chief minister, council of ministers, and the advocate general of the state. Governor we have not discussed yet, but we will discuss him now. State legislature consists of governor, legislative assembly, legislative council. We have discussed legislative assembly, we have discussed legislative council. Now let's come to the office of the governor of a state.
Hello, everyone, and welcome to Political Current Affairs Removal of Speaker in the State Assemblies. This topic is in news because the Kerala Legislative Assembly rejected a motion moved by the opposition, primarily one IUML MLA M. Omer, seeking the removal of the Speaker P. Sri Ramakrishnan. Now, again, let's be very clear P. Sri Ramakrishnan was the Speaker in January 2021. As of now, MB Rajesh is the Speaker after the elections that took place in April May 2021. Okay, so what was the charge? The allegation was that the Assistant Private Secretary of the Speaker had already been questioned by the customs for 9 hours in some diplomatic channel gold smuggling case, and even some press reports had made some allegations that the speaker was also involved in gold smuggling. Apart from this, the opposition also made some allegations that the speaker had got himself involved in some wasteful expenditure, meaning thereby that the speaker had gone ahead and had invested some money in the renovation of the complex, the Legislative Assembly complex, which was a wasteful expenditure. So based on all these charges, the speaker, the opposition said, had no right to continue because by this person, by the virtue of him being the speaker, it was going against the decorum of the house. This was the basic news, and the assembly rejected such a motion. Now for us, what becomes important is the background. How do you remove a speaker? What are the conditions involved? So on and so forth. So let's see those conditions. As far as the removal of the speaker in the assembly is concerned, the provisions are mentioned under Article 179, and these provisions are exactly the same as that mentioned at the parliamentary level under Article 90. Exact same provisions. So what are the provisions? Number one, a resolution for the removal of the speaker can be tabled in the lower house by any member, whether that person is a minister, a private member, opposition party, ruling party, does not matter. Number two, such a resolution has to be or can be tabled only after giving 14 days notice. Prior notice has to be given to the house that, sir, ma'am, I want to raise a motion. I want to present a resolution to remove you. The presiding officer. Now, as and when this resolution is passed, eventually, this has to be passed by the majority of all the then members of the house. This majority is called effective majority. Meaning what? What is effective majority? Total strength minus vacancy. More than 50% of this is what is called effective majority. For example, let's say the total strength of a house is 200. This means there are 200 MLAs. Suppose 5 MLAs have passed away or they have resigned. That means there is a vacancy. 5 seats are vacant. What is the effective strength? All the then members, 195. So if there is some provision which requires an effective majority, this means more than 50% of this value, 195. This means what? Find out 50% of 195 and it should be more than that. This value would come to 98. So if 98 MLAs support whatever is the point, that bill, that proposal, that motion, that resolution is approved. That is what's called effective majority. Majority of all the then members, meaning total strength minus vacancy. This is a way how you remove the speaker in the Legislative Assembly as well as the speaker of the Lok Sabha. Exact same provision. No difference. Then some other provisions are mentioned under Article 181 of the Indian Constitution. What is that? When such a resolution is passed or are presented in the House, the speaker will not preside over the House. Otherwise, it is going to be very absurd and strange. The speaker presiding over the House, where the discussions are going on his nature, on his character. So, in such a situation, the deputy speaker presides over the House. It is the deputy speaker who will take care of the session, who will run the session. Also, the speaker in this case acts as an ordinary member, meaning he has a right to present, right to speak, right to even vote in the first instance. I hope you are aware that under normal circumstances, speakers do not have a right to vote in the first instance. They can only have a casting vote, meaning what? They can vote only in case of a tie. If there is a tie, then the speaker can vote. Otherwise, no. But since the speaker here is no more the speaker, he or she is being treated as an ordinary member, he has a right to vote in the first instance. And it is the deputy speaker who takes care of the House, the proceedings of the House. So these are some other provisions with respect to the removal of the speaker. And just one more point, if the speaker wants to resign on his own, then the speaker submits his resignation to the deputy speaker, not to the chief minister or any other person, neither to the governor nor to the chief minister, but to the deputy speaker. So if the speaker wants to resign, a very important point is that he or she should submit his or her resignation to the deputy speaker. On a lot of occasions, UPSC has and can ask questions on these minute points. So these points also need to be taken care of. So that's all as far as this particular topic was concerned. Let's look at a practice question. Consider the following statements regarding removal of the speaker of the Legislative Assembly. The resolution to remove the speaker needs to be passed by simple majority of the Legislative Assembly. The resolution can be moved only after giving 14 days advance notice. Select the correct answer using the codes given below. 1, only 2, only both, 1 and 2, neither 1 nor 2. Let's read the first statement. The resolution to remove the speaker needs to be passed by a simple majority. No, this is wrong. It needs to be passed by an effective majority of the effective strength of the House. This is wrong. One is wrong. Let's come to the resolution can be moved only after giving 14 days advance notice. What is this advance notice? Which you have seen. This advance notice is to inform the House that I want to move a resolution to remove the speaker with proper reasons. I feel there are some allegations, some conditions. The person who continues to hold the post may not be doing justice to the post. He or she, by virtue of holding the post, is affecting the dignity, the decorum of the House. He or she needs to go. Here is a resolution with these allegations. 14 days advance notice is required. So second statement is absolutely correct. One is wrong. Who is right? The right answer is B. 2 only. That's all for this topic. Thank you.
Now let us look at the office of governor. Who is a governor? How the governor is appointed? What are the qualifications in order to be appointed as the governor of a state? What is the tenure of a governor? What are the powers and responsibilities and roles of a governor? Should the office of governor continue? Because there are some who say the office of governor should continue in our political system, and there are also others who say the office of governor is the relic of colonial era and should be discarded into the dustbins of the history. We will look at all this and much more. Let's get started with who is a governor. The governor is basically performing dual role. At one, he is the constitutional head of the state, and at the same time, he is the constitutional link between the center and the state. I'll repeat, the governor performs dual role. He is the constitutional head of a state, which means when we look at the state executive is headed by the governor, then we have the chief minister and his council of ministers, and then the advocate general of a state. This governor is also an integral part of the state legislature. Why is the governor an integral part of the state legislature? Because no bill becomes an act unless and until the governor gives his assent. That means governor is an integral part of the state legislature because no bill passed by the state legislature can become an act, can enter into force unless and until the governor gives his or her assent. That is why we say the governor is an integral part of the state legislature as well. So the governor plays dual role. Originally, the constitution said that there has to be a governor for every state. That means one governor for one state. But the constitution was amended. The year was 1956. Seventh Constitutional Amendment Act. What Seventh Constitutional Amendment Act did? It said a governor can be appointed to more than one state as well. Which means we may have a governor who is common to more than one state. Originally, one governor for one state. Because of Seventh Constitutional Amendment Act 1956, we may have a governor who is common governor to more than one state as well. But what are the roles and responsibilities performed by the governor? How the governor is appointed? What are the qualifications required for someone to be appointed as the governor of a state, the governor is appointed by the president. But again, this is not the discretion of the president. We have understood at least now that president is a mere rubber stamp, unfortunately, in our political system. That means somebody who is recommended by the prime minister, this person is appointed as the governor by the president of India. That means this governor is appointed to a state by the president of India, basically on the advice of the prime minister. And this governor holds office during the pleasure of the president. This is where we come across this doctrine again, doctrine of pleasure. That means the governor of a state remains in office as long as he enjoys the confidence of the president, which basically means as long as he enjoys the pleasure of the prime minister. If prime minister wishes, he will advise the president, the governor of a state will be removed. That means the governor does not enjoy security of tenure. Tomorrow, if there is a question in your examination, the governor is appointed for a period of 5 years, and this is something that is mentioned in the constitution. No, there is no term, no tenure mentioned in the constitution for the governor of a state. The governor is appointed by the president, and this is where we come across doctrine of pleasure. That means he does not enjoy security of tenure. That means constitution has not fixed a term for the office of governor. But who can be appointed as the office of governor? Before we address this question, we need to understand why governor is appointed, why governor is not elected. And the same argument as we discussed in the office of the president, same arguments we can discuss here as well. Constituent Assembly, when it discussed the provisions relating to the office of the governor, Constituent Assembly also debated whether the office of governor should be an elected one or an appointed one. And the Constituent Assembly realized that we should not have election to the office of governor. The governor should be appointed by the president. And this is where the doctrine of pleasure comes into picture. But why did the Constitution not deal with the election of the governor and only with the appointment of the governor? For that, we have to discuss few reasons. Reason number one, if the real power is with the Council of Ministers, headed by the Chief Minister, the governor is only a constitutional head of the state, is only a nominal head of the state. Why should we have election to the office of governor as well? Because then there will be friction. There will be friction between the office of governor and the office of the Chief Minister. To resolve this friction, the office of governor is an appointed one, not elected one. And at the same time, when the real power is with the Chief Minister and the Council of Ministers, why should we spend time, energy, resources, money into organizing election for the office of the governor? That is why it is against the principle of parliamentary democracy. If parliamentary democracy says Council of Ministers headed by the Prime Minister is accountable to Lok Sabha, if parliamentary democracy says Council of Ministers headed by the Chief Minister is accountable to the Legislative Assembly, it goes against the principles of parliamentary democracy to have an elected president, to have an elected governor. That is why, please remember three things. One, the office of governor is appointed because if we have an elected governor, it goes against the principles of parliamentary democracy. Number two, if we have an elected governor, then there will be friction between an elected governor and the elected Chief Minister as well. Reason number three, if the real power is with the Council of Ministers headed by the Chief Minister, so why should we have election to the office of governor as well? Don't you think it will be wastage of time, money, resources? That is why, for these three simple reasons, we have an appointed governor, we do not have an elected governor. Let's recap. The governor, constitutional head of a state, as well as constitutional link between the center and the state. That's number one. Number two, originally Constitution said one governor for every state, one governor for one state, but later on, 7th Constitutional Amendment Act 1956, it said we can have a governor who is common to more than one state as well. But we have an appointed governor. The governor is appointed by the president on the basis of the recommendations of the prime minister, which means the governor is appointed by the president, and this is where we also come across doctrine of pleasure. He holds office till the time he enjoys the pleasure of the president, which basically means the pleasure of the prime minister and his council of ministers. But who can be appointed as the governor of a state? Constitution has prescribed two qualifications, and please remember this carefully. There are only two qualifications prescribed in the Constitution for someone to be appointed as the governor of a state. If you are a citizen of India, you have completed 35 years of age, you are eligible to be appointed as the governor of a state. But additionally, two conventions have also resulted. What is a convention? Unwritten rule, not mentioned anywhere, but something that we follow. And what are these two conventions vis-a-vis the office of governor? Convention number one: whenever governor to a state is to be appointed, the chief minister of that state shall be consulted. This consultation with chief minister is not mentioned in the Constitution, but this is a convention that we have been following. Unwritten rule that we have been following. Convention number two: he should not be the resident of that state to which he is appointed. That means if a governor to Karnataka is to be appointed, he should not be the resident of Karnataka. He should be basically from outside the state, not from the state to which he or she is to be appointed. But both these conventions have been violated as well. For example, the governor to Bihar was appointed, chief minister was not consulted. Governor to Karnataka was appointed, Mr. Bala, who was previously the speaker of the Legislative Assembly of Gujarat, he was appointed as the governor to Karnataka. The chief minister got to know from the media, from the press, that Mr. Bala has been appointed as the governor of Karnataka. And there was one instance when a governor to Karnataka was appointed and he was the resident of Karnataka. So two qualifications have been prescribed by the Constitution for someone to be appointed as the governor of a state. Qualification number one, citizen of India. Qualification number two, you must have completed 35 years of age. But additionally, two conventions have also resulted. But unfortunately, both these conventions have been violated as well. But which are these two conventions? A governor to a state, when he or she is appointed, consult the chief minister. Two, the governor to a state is appointed, but he or she should not be the resident of that state to which he or she is to be appointed. But there are three things that we need to discuss as well. Number one, let's say for example, I am appointed as the governor of a state. I should not be the member of the parliament. I should not be the member of the state legislature. If I am a member of the parliament or the member of the state legislature, but now I am appointed as the governor of a state, the moment I enter the office of the governor of a state, which means the moment I am administered oath of office by the Chief Justice of that High Court, I shall be deemed to have vacated that seat. That means I am appointed as the governor of a state. I should not be the member of the parliament. I should not be the member of the state legislature. If I am, the moment I enter into my office, which means the moment I assume the charge of the governor of that state, it shall be deemed that I have vacated my seat as well. That's point number one. Point number two, I should also not be holding any office of profit. Another important point. And what is this office of profit? We have discussed in the union legislature. Third point. For example, I am appointed as the governor to Karnataka as well as Tamil Nadu. But my allowances, my emoluments, they have to be shared between Tamil Nadu and Karnataka. Why should only Tamil Nadu bear this burden? Why should only Karnataka bear this burden? So emoluments, allowances that have to be paid to me, they have to be shared between Tamil Nadu and Karnataka. Who will determine what is the proportion of the share? This will be determined by the president. That means president may say 50% Tamil Nadu should give, 50% Karnataka should give, or 40% Karnataka should give, 60% Tamil Nadu should give. Okay? Now I'm appointed as the governor. I'm appointed as the governor to a state by the president of India based on the recommendation of the prime minister. But before I enter into office, I will be administered oath of office. And who will administer me oath? The Chief Justice of that High Court. I'm appointed as the governor of Karnataka. My oath will be administered to me by the Chief Justice of the Karnataka High Court. If she is not present, then any senior most judge of the Karnataka High Court. But what is mentioned in this oath? Number one, I will faithfully execute the duties of my office. That's number one that is mentioned in the oath. Number two, I will protect and defend the constitution and the law. That's also something that is mentioned in the oath. And number three, I will devote myself to the well-being of the people of my state. These are the three things that are mentioned in the oath of the governor. Chief Justice of that High Court will administer me the oath, and I will continue as the governor of that state. And normally my term is for 5 years. Normally the term of the office of the governor is for 5 years. But this 5 years is subject to the doctrine of pleasure. That means as long as the president is satisfied with me, I will continue to be the governor of that state, which basically is the pleasure of the prime minister. For example, in 1989, VP Singh government asked all these governors appointed by the previous Congress government, you please resign. And in 1991, when the Congress government came back to power, it did the same thing. All those governors appointed by the VP Singh government, they were asked to go. Similarly, 2014, Prime Minister Modi was sworn in as the Prime Minister of India. Almost all the governors appointed by the previous Congress government, they were either sacked or they were asked to resign. There were few exceptions. For example, the governor of Nagaland was not touched, the governor of Andhra Pradesh and Telangana was not touched, the governor of Jammu and Kashmir was not touched, the lieutenant governor of Delhi, then Najib Jung, he was also not touched. But in these few exceptions, almost all the governors appointed by the previous Congress government, they were asked to either resign or they were sacked. The governor may also resign, and the governor submits his resignation to the president, because who is the appointing authority? President. If president has appointed you, you will have to submit your resignation to the president as well. Sometimes a governor may die. And when the governor dies, what president does? He appoints the neighboring governor, the governor of a neighboring state, to act as the governor of this state as well. For example, in 2020, the governor of Madhya Pradesh died, and the president asked the governor of Uttar Pradesh to act as the governor of Madhya Pradesh. That's also something that can happen. But what are the powers and functions of the governor? This is where, just like the president of India, we can categorize the powers of the governor into various heads. So some powers are executive in nature. He also enjoys legislative powers. He also enjoys financial powers. He also enjoys judicial powers. What are these executive powers of the governor? Executive power of the governor is governor appoints the chief minister. That's his executive power. On the advice of the chief minister, other council of ministers are appointed by the governor. That's his executive power. The governor appoints advocate general of the state. That's his executive power. The governor is the chancellor of state universities. That's his executive power. The governor also appoints state election commissioner, because it is a state election commission which is responsible for the conduct of Panchayati Raj elections, for the conduct of municipal elections. And for that, we have a state election commissioner. And this state election commissioner is appointed by the governor of that state. It's also his executive power that he appoints the chairperson and members of State Public Service Commission. These are his executive powers. But he has got some legislative powers as well. Just like the president of India has legislative powers. For example, who can summon parliament? President. Who can prorogue parliament? President. Who can dissolve Lok Sabha? President. In a similar fashion, who can summon legislative assembly? Governor. Who can prorogue legislative assembly? Governor. Who can dissolve legislative assembly? Governor. We will have to wait and watch whether this is the discretion of the governor or governor does this on the advice of the chief minister and the council of ministers. But we will discuss that. Similarly, his legislative power is he gives his assent to a bill. Similarly, his legislative power is that he can also promulgate ordinance. Just like the president promulgates ordinance under Article 123 of the Constitution, in a similar fashion, the governor can also promulgate an ordinance under Article 213 of the Constitution. When the legislative assembly is not in session, the governor can promulgate an ordinance with respect to that state. Similarly, he has other legislative powers. Legislative powers such as he addresses the legislative assembly when it is convened for the first time after the election, just like president does. Similarly, the budget session, the first day of the budget session, he addresses the legislative assembly. That's his legislative power. Similarly, when we discuss the office of president and when we discuss the disqualification of the members of the parliament, a member of the parliament can be disqualified on the grounds of office of profit, on the grounds of mental unsoundness, on the grounds of change in the nature of citizenship, on the grounds of adjudged insolvent. Right? How are these MPs disqualified? Election Commission submits a report to the president, and this report is binding on the president. President disqualifies these members of the parliament. In a similar fashion, the member of a state legislative assembly or the state legislative council can also be disqualified on these grounds, on the grounds of holding office of profit, mental unsoundness, change in the nature of citizenship, adjudged insolvent. Right? Here also, who disqualifies these MLAs or MLCs? Governor, on the basis of the report of the Election Commission of India, and this report of the Election Commission of India is binding on the governor. That means when we compare the office of president with the office of governor, more or less they have the same powers. Executive powers, legislative powers, financial powers as well. For example, money bill cannot be introduced in legislative assembly without the previous consent of the governor. Financial bill cannot be introduced in the legislative assembly without the previous consent of the governor of that state. Similarly, at the state level also, as we have discussed, there is something called contingency fund of that state. The money can be withdrawn from the contingency fund of that state by the governor. That's also his financial power. Similarly, the governor has veto powers. Which of these veto powers? When a bill is passed by legislative assembly, it is sent to the governor. The governor may give his assent to this bill. The bill is passed. There is no controversy. The governor may say, "I'm not going to sign this bill." Absolute veto. The bill is dead. It can never become a law. Second, the governor may ask that this bill be reconsidered by legislative assembly. Suspensive veto. That's also his veto. Third, pocket veto. The governor may not act on this bill at all. He may keep the bill lying on his desk, lying in his pocket. Pocket veto. Problem solved. But additionally, the governor may also reserve a money bill for the consideration of the president. And when a state bill is reserved for the consideration of the president of India enjoys absolute veto over such bills. Long story short, when we look at the office of the governor enjoys various powers. Executive powers can be compared to that of the president, but at a state level. Legislative powers can be compared to that of the president, but at the state level. Financial powers can be compared to that of the president, but at the state level. And we have discussed all these powers when we discuss the office of the president, so we don't have to repeat them here because these powers are mostly similar. Veto power, absolute veto, suspensive veto, pocket veto. Additionally, the governor may reserve any bill for the consideration of the president. And when governor reserves any bill for the consideration of the president enjoys absolute veto over such bills. If the president says, "Don't sign this bill," the bill is dead. It will never become a law. But now let's look at the pardoning power. Because when we discussed union executive, then we discussed president of India. I told you pardoning powers of the president we will discuss when we will discuss the office of governor as well. So what is this pardoning power that is available to the president under Article 72 of the Constitution, and that is something available to the governor as well. President enjoys these pardoning powers under Article 72. The governor enjoys under Article 161 of the Constitution. But there is a difference, and we will explain what the difference is in the pardoning powers of the president and the pardoning powers of the governor. But first up, why should there be a pardoning power available with the president or the governor? I am accused of a crime. District Court said you are guilty, you hang till death. I approached High Court. High Court said you are guilty, you hang till death. I approached the Supreme Court. Supreme Court also said you are guilty, you hang till death. The only legal recourse that I have, the only option that I have, the only alternative that I have, I'll approach the president and I will file a mercy petition. And president has various powers when it comes to this mercy petition. The president of India may pardon me. The president of India may commute my sentence. The president of India may also remit my sentence. The president may grant me respite. The president may grant me reprieve as well. What is pardon? Pardon means if the president has pardoned me, I'm as if I am born out of the womb of my mother now, as if I have not committed any crime. Which basically means if the president pardons me, not only am I set free, but any disqualification that is attached to my conviction, that disqualification also disappears. What is that disqualification? Let's say, for example, normally if an individual is sentenced to a jail term, this individual may not tomorrow apply for a government job. This individual may also not be eligible to do various kinds of things. Maybe this individual has to report to a police station every now and then for some time. That means once you are convicted, there are some disqualifications attached to you as well. If the president pardons me, I am absolved of my crime, I am set free, and no disqualification is attached to me. That means I am as pure as if I am born out of the womb of my mother now. I am set free. That's pardon. But the president is not pardoning me. The president is commuting my sentence. Commutation means one sentence was awarded to me, replace it with a lesser sentence. 1 degree lesser. I was sentenced to death. Replace it with life imprisonment, but rigorous life imprisonment. I was sentenced to life imprisonment, rigorous life imprisonment. Now my sentence was commuted to life imprisonment, but simple life imprisonment. I was sentenced to life imprisonment, simple life imprisonment. I approached the president, filed a mercy petition. He commuted my simple life imprisonment to 10 years. I was sentenced to 5 years in jail. President commuted the sentence to Fine. That means this is the power that is available to the president. President may pardon me. When president pardons me, I am as pure as I'm born out of the womb of my mother. That means no disqualification whatsoever. Any disqualification which was attached to my conviction, that also has disappeared. If not pardoned, the president may commute. That means death sentence commuted to life imprisonment commuted to 10 years, 10 years commuted to 5 years, 5 years commuted to 1 year commuted to fine. That's also the power that is available to the governor. Or the president may remit my sentence. What is this remit? Let's say, for example, I was sentenced to 10 years in jail, rigorous imprisonment. This sentence has been remitted. Now I will be sentenced to only 5 years in jail, but the character of this sentence will remain the same. That means the character was rigorous imprisonment, character will remain rigorous imprisonment, but only the duration has changed from 10 years to 5 years. But then there is respite. Respite is, for example, there is a pregnant woman who has been sentenced to jail, but because of his pregnancy, his 10 years have been reduced to 5 years. But she was sentenced to 10 years of rigorous imprisonment. Now her jail term is reduced to 5 years, but character also has changed. Now this rigorous imprisonment becomes simple imprisonment. It is because she was pregnant. Let's say, for example, there is an individual who was sentenced to 10 years jail, rigorous imprisonment. But in jail, he met with an accident. Maybe he fell from the top floor, he broke his limbs, or he has got some brain damage. It's because of his physical disability that his term has been reduced from 10 years to 5 years, for example. But character also changes. He was sentenced to rigorous imprisonment. Now he is sentenced to simple imprisonment. And then there is reprieve. Reprieve is basically temporary stay. And this is normally invoked in case of death sentence or death penalty. Don't execute this individual, I'm granting him reprieve. Don't hang this individual, I'm granting him reprieve. I'm the president of India. Why? Because he will file his mercy petition. I will look at his mercy petition till that time. Don't execute him. Temporary reprieve is granted to this individual. All these are the powers available with the president under Article 72. But again, this is not the personal discretion of the president. President has to take this decision of either granting pardon, commute, remit, respite, reprieve on the advice of the Home Minister. That's what the Supreme Court has said in multiple verdicts, that the president has to take this decision on the advice of the Ministry of Home Affairs. But the bigger question is, why should these powers be given to the president of India? If the Supreme Court has said you are guilty, you hang till death, who is president to pardon this individual? Who is president to commute this imprisonment? Who is president to grant remit, reprieve, respite to this individual, to this convict? This is because, and this is the power that is available to a US president as well. This is the power that is given to the executive. Why? Because let's say, for example, I am accused of a crime and I'm produced before the court. Court will look into only one aspect, whether I'm guilty or not. Court will look into the evidence, whether evidence points to the fact that I am guilty or not. Court will not look into any other factor, but just whether I am guilty or not. Just whether evidence is in favor of me or against me. Just this. But president can go beyond this. Let's say, for example, there's a problem in Jammu and Kashmir, or there's a problem in Nagaland, or there is some problem in Manipur. Let's say, for example, now there are terrorists, there are international elements, there are separatists who have been booked under sedition, or who have been booked under waging war against the country. And there are 20 people who have been sentenced to death. 20 terrorists, separatists, international elements, they have been sentenced to death by the Supreme Court. And the Supreme Court has confirmed that they have waged war against the country, they should be hanged till death. But now suddenly there is some peace talk going on to resolve these conflicts in Kashmir, in Nagaland, and Manipur. And these individuals who have been sentenced to death, they should also be involved in those peace talks. But they have been booked, they have been convicted, they have been convicted for waging war against the country. So there is evidence against them. We cannot set them free. But president, on the advice of the Home Minister, basically on the advice of the Prime Minister, what president could be recommended? That please pardon them. Why? Because let's have a new beginning in Jammu and Kashmir, in Nagaland, and Manipur. These individuals who have waged war against the country, now they have decided that there should be peace. Peace should be given a chance. They have decided to join the mainstream. President is empowered to pardon them. So basically, it's a political decision. It is a political power given to the President of India by the Constitution. And luckily, this power has not been misused by the President of India. Because if you look at US President Donald Trump, he used his pardoning power to pardon his friend. And that misuse is something that we have not seen committed by the President of India. Similar power is available with the governor of a state as well, but with some difference. President alone can pardon a death sentence. Governor cannot pardon a death sentence. Governor can only commute a death sentence. That means governor cannot pardon a death sentence. President can. President can say, I am pardoning you. You are as if you have just gone out of the womb of your mother. That's pardon. But death sentence cannot be pardoned by the governor. Death sentence can only be commuted by the governor. Second difference. President can use his pardoning powers if you have committed crimes against the central laws, or if you have committed crimes which are crimes under various central laws. The governor can use this pardoning power if you have committed these crimes under the state laws. That's another difference. And the third difference is, president can also pardon somebody who is guilty in a court martial. For example, army man has committed a crime for which he was sentenced to life imprisonment by a court martial. He can still approach the president, and president can use his pardoning powers. But governor cannot do that. Governor does not have the power to use his pardoning powers when it comes to proceedings under the court martial. And governor also uses all these powers on the advice of the Council of Ministers headed by the Chief Minister. That's the difference between the pardoning power of the president and the pardoning power of the governor.
Now, let us discuss something very interesting and very important as well for your exams. Governor
performs a dual role. He's the constitutional head of the state. He's also a constitutional link between the center and the state. How is the governor appointed? How is the governor removed? What are the qualifications required for someone to be appointed as the governor? What are the various powers available with the governor? Executive powers, legislative powers, financial powers, judicial powers, veto powers. But let's look at something very important. Article 163 of the Constitution, it is similar to Article 74 of the Constitution, but with one major difference. And that's why we say President of India only enjoys influence, but the governor of a state enjoys influence as well as power. Article 74, there shall be Council of Ministers headed by the Prime Minister to aid and advise the President, who shall act on that advice. That's what is mentioned vis-a-vis President and the Prime Minister and his Council of Ministers. In a similar fashion, we have Article 163 of the Constitution. It says, there shall be Council of Ministers headed by the Chief Minister to aid and advise the governor, who shall act on that advice, except in so far as he has to act in his discretion. Which means, there shall be Council of Ministers headed by the Chief Minister. To do what? To aid and advise the governor, who shall act on that advice. Chief Minister advising the governor, please appoint this minister. He's bound by that advice. Please appoint Advocate General of that state. He's bound by that advice. Except when the governor has to act in his discretion. What is discretion? When the governor has to act on his own without the aid and advice of the Chief Minister and his Council of Ministers. So governor can do anything in his discretion. And the big part is, if there is a dispute as to what constitutes the discretionary power of the governor, Constitution says the position of the governor shall be final. That means whenever there is a dispute as to what constitutes the discretionary powers of the governor, when is it? that the governor has to act in his discretion without the aid and advice of the Council of Ministers headed by the Chief Minister. If there is this dispute, the governor's word is final. Long story short, governor gets to decide what are my discretionary powers. And it is this clause in our constitution which leads to conflict between the Chief Minister and the governor, which leads to conflict between an elected Chief Minister and an appointed governor, which leads to a conflict between the Chief Minister elected by the people of that state and the governor appointed by the centre, and which violates to some extent and which sometimes strains the federal relationship between the centre and the state. But where is the governor using his discretion? Discretion number one, he sends fortnightly reports to the president. And what is mentioned in these fortnightly reports? How the administration of the state is being carried out. This report is sent by the governor to the president, and while preparing this report, he is not bound by the aid and advice of the Chief Minister and the Council of Ministers. Another discretion. Number two, when he is recommending President's rule under Article 356. Under Article 356, the governor submits a report to the president. That is breakdown of constitutional machinery. While preparing this report, submitting this report, he is not bound by the aid and advice of the Council of Ministers headed by the Chief Minister. The governor can reserve any bill for the consideration of the president. Any bill for the consideration of the president. That is his discretionary power. The governor can even reserve a money bill for the consideration of the president, and president enjoys absolute veto over such bills. But there is one constitutional obligation. Remember this carefully. The governor can reserve any bill for the consideration of the president. Any bill, including a money bill. But one bill he must reserve for the consideration of the president. One constitutional obligation of the governor, that this bill you have to reserve for the consideration of the president. If the Legislative Assembly is passing a bill, and through this bill the powers of the High Court is threatened. That means that the Legislative Assembly is passing a bill and it is clipping the powers of the High Court. It is snatching the powers of the High Court. It is limiting the scope of the High Court. Such a bill, necessarily, the governor has to reserve for the consideration of the president. Otherwise, he can reserve any bill for the consideration of the president. But a bill threatening the High Court, he must necessarily. It's a constitutional obligation on him. You have to reserve this bill for the consideration of the president. But this discretionary power, it has not been codified. This discretionary power, it has not been mentioned that these are the discretionary powers. And when it is not mentioned that these are the discretionary powers, this is what leads to conflict between the governor and the Chief Minister. And what is the criticism? This discretionary power is being misused by the governors in choosing a Chief Minister. For example, Karnataka elections took place. BJP emerged as the single largest party. Congress and JDS, Janata Dal Secular, they both decided to come together to form the government. They had the numbers. But the governor said, no, I will invite the leader of the single largest party, which is the BJP, you form the government. Inviting leader of the single largest party, you form the government. Okay. But look at what happened in Goa. In Goa, Congress emerged as the single largest party. The governor invited the BJP, which is the second largest party in the Legislative Assembly. So here the convention was violated. Similarly, in Manipur, Congress again emerged as the single largest party. But the governor invited the leader of the second largest party, the BJP, you form the government. So when Constitution says Chief Minister shall be appointed by the governor, normally there is no confusion. Because the party which has won the election, the leader of that party becomes the Chief Minister. But the problem is when there is a hung assembly, when no party has a clear-cut mandate by the people, it is in this situation that governor plays a partisan role. The governor who is appointed by the central government, the party which is in power in the central government, is favored in that state. So in choosing a Chief Minister, the governor is misusing his discretionary power. Second, in testing the majority. Now, this is something hilarious. Sachin Pilot, the then Deputy Chief Minister of Rajasthan, he revolted against the Chief Minister. The Chief Minister dismissed him. The Chief Minister asked the governor, please remove Sachin Pilot. He was removed as the Deputy Chief Minister. But the Chief Minister then is asking the governor, please do one thing. Call the session of Legislative Assembly. I want to prove my majority. That I have the majority on the floor of the Legislative Assembly. Governor is not convening the session. But on the other hand, the governor, even without asking the Chief Minister to prove your majority, he was dismissed. That's what happened in Karnataka. S.R. Bommai was the Chief Minister. He was the Chief Minister. Some MLAs, they wrote letters to the governor that we are withdrawing support to S.R. Bommai, which means S.R. Bommai has lost his majority. S.R. Bommai went on to meet the governor and pleaded before him, I have a majority, give me an opportunity. Give me an opportunity. I will test my majority on the floor of the Legislative Assembly. The governor said, no, you don't have a majority, you're dismissed. That means in testing the majority, the governor is misusing, abusing his discretion. Similarly, in dismissing the Chief Minister, you don't have a majority, you're dismissed. Similarly, in dissolving the Legislative Assembly, he is misusing his discretion. In recommending President's rule, he is misusing his discretionary power. In reserving the bills for the consideration of the President, he is misusing his discretionary power. That means when Constitution says there shall be Council of Ministers headed by the Chief Minister to aid and advise the governor who should act on that advice, except when he is to act in his discretion. Since what are these discretionary powers? They are not codified, they are not mentioned in the Constitution. The governors have been misusing these discretionary powers. And why are they misusing? Because they do the bidding of the central government. Because it is the central government who has appointed them, and they are accountable not to the people of that state, but to the central government. That is why they are favoring the central government. They are being partisan in favor of the central government, in favor of the ruling party at the center. And on top of that, there is also another criticism that who are these governors who are appointed? These governors are failed politicians or retired politicians who are now in one way or the other to be rehabilitated by the party. For example, there is an unwritten rule of the central government, the government headed by the BJP, that if a particular member crosses the age of 75, you can no longer continue as a minister. Which means that since you cannot continue as a minister, but we have to rehabilitate you somewhere, this person is appointed as a governor. Najma Heptulla, she was the minister under the Modi government. She crossed the age of 75. Now she's to be rehabilitated. She was appointed as the governor of Manipur. Kalraj Mishra crossed the age of 75. Can no longer continue as a minister. Can no longer continue as a minister. Appointed as a governor. That means now this governor's office, Raj Bhavan, is now becoming the retirement home of failed politicians. Retired politicians. Why should governor's office be dominated by the politicians? Why can't we have people from eminent walks of life who will not be partisan to various political parties? Why shouldn't these eminent persons be appointed as governors to the states? This is what Sarkaria Commission said. And this is where we come across reforms that we need to implement so that we can preserve the sanctity of the office of the governor. For example, what happened in Arunachal Pradesh? 2016, Arunachal Pradesh. Congress was the single largest party. It had the absolute majority. It formed the government. After some time, there was a revolt. Nabam Tuki was the Chief Minister. His cousin brother, Nabam Redia, he was the Speaker. Some Congress MLAs revolted. What happened? The Chief Minister is advising the governor, please convene the session of State Legislative Assembly. Governor did that. Later on, governor preponed the session. The session was to begin in January. He preponed it to December. Matter went to the court. Supreme Court said, in a very famous case, Nabam Redia, that the governor can convene the session of Legislative Assembly only on the advice of the Council of Ministers headed by the Chief Minister. So it was left to the Supreme Court to say that this is not your discretionary power. Otherwise, governor had said, this is my discretionary power. I can convene the session of Legislative Assembly at the time and place of my choosing. So should we wait for the Supreme Court to come in? Should we wait for the Supreme Court to decide and tell us what are these discretionary powers? Let's implement some reforms. And for that, we have to go back to Sarkaria Commission recommendations. Sarkaria Commission was set up in 1983 on center-state relations. And specifically on the office of the governor, it recommended few reforms. If these reforms are implemented, it will go a long way in depoliticizing the office of the governor. What are these reforms? Reform number one, a person to be appointed as the governor should satisfy the following criteria. Criteria number one, he should be eminent in some walk of life. That means why should the office of governor be reserved for politicians only? We can have eminent persons also occupying the Raj Bhavan. Second, he should be a person from outside the state so that he is not too intimately connected with the politics of that state. Third, should be a detached figure, not too intimately connected with the local politics of that state. Detached figure, so that he doesn't care what is the local politics of that state going on, so that he will only abide by the constitution, the law of the land. Detached political figure. He should be a person who has not taken too great interest in politics generally, and particularly in the recent past. This is how we can depoliticize the office of governor, which means Sarkaria Commission recommended these reforms. Unfortunately, have not been implemented. If they are implemented, it will go a long way in depoliticizing the office of governor. Sarkaria Commission said something else. The BJP government at the center, there is Trinamool government in West Bengal, right? And there's a tussle between the chief minister and the governor. Why? Because the governor is a BJP person, appointed by the BJP government at the center. That too in a state which is ruled by the opposition. It is desirable, says the Sarkaria Commission, that a member of the ruling party at the center should not be appointed as the governor of a state which is ruled by the opposition party. Please implement this. Another recommendation of the Sarkaria Commission. I told you at the beginning there are only two qualifications required for someone to be appointed as the governor of a state. Citizens of India must have completed 35 years of age. But additionally, two conventions have also developed. Consult the chief minister. But we don't consult the chief minister. If the chief minister is from the opposition political party, we don't consult the chief minister. Sarkaria Commission said this consultation should be necessary. And in fact, it should be mentioned in the constitution that while appointing the governor to a state, the chief minister shall be consulted. And last important recommendation, security of tenure. Why is it that governors do the bidding of the ruling party at the center? Why is it that the governors are partisan in favor of the ruling party at the center? Why is it that? It is because the governor does not enjoy security of tenure. And it is this lack of security, which is like a Damocles sword on top of the head of the governor. If I don't follow the diktat of the ruling party at the center, I will be removed, I will be dismissed, I will be transferred. And it is because of this that the governors play partisan politics. And for that, Sarkaria Commission said security of tenure. Just like we have security of tenure for the president, let's have security of tenure for the governor. Let's say the office of governor should have a tenure of 5 years. But even before 5 years, governor can be removed. But president cannot remove the governor. Governor can be removed based on the resolution passed by both houses of the Indian Parliament, that too by special majority. That means it is the security of tenure which will go a long way in depoliticizing the office of governor. But now let's come to very important questions. One set is office of governor should be abolished. Another one says office of governor should continue. Third one says there should be reforms in the office of the governor. So we have discussed Sarkaria Commission recommendations. If they are implemented, because they are not implemented yet, if they are implemented, it will go a long way in depoliticizing the office of governor. Second is office of governor is necessary. Why necessary? Because during president's rule, when there is breakdown of constitutional machinery in a state, the governor is somebody who discharges the duties of the executive. It is the governor who takes care of the administration of that state. In absence of the governor, who will do that? That means the office of governor is very important, considering the fact that there can be breakdown of constitutional machinery in a state. And in that case, to ensure continuity in governance, the office of governor is necessary. In absence of the governor, who can fill this role? Who can fill this gap? That is why office of governor is indispensable. But there are others who say, do we need the office of governor? And for that, let's go back to the Constituent Assembly debates and the origin of the office of the governor. You would know that the Government of India Act 1935, it established provincial legislative assemblies. These legislative assemblies would pass bills, basically make laws. But to retain the power of the crown, to retain the power of the British government, they gave the power to the governor that what you can do, you can veto these bills. That means although on paper, Government of India Act 1935 established provincial legislative assemblies, they were given the powers, please make laws. Please make laws for the people of your state, for the people of your country. But if this provincial legislative assembly goes against the British crown, for that we have a defender. Who is the defender? Governor. And when this bill is submitted to the governor for his signature, he will not give the signature. So to safeguard the interest of the British crown, we had retained the office of governor. But after the independence of India, after the commencement of the Constitution of India, why should we have this office of governor? In Constituent Assembly, there were heated debates about the office of the governor. K.T. Shah said there will be conflict, and that is something that we are witnessing today. K.T. Shah said there will be conflict between an unelected governor and the elected chief minister and his council of ministers. Don't retain the office of governor. But what we did, the provisions related to governor that were mentioned in Government of India Act 1935, we have retained the same provisions in our constitution as well. But what was the logic? Two logics. Logic number one, Constituent Assembly said that there is a dearth of competent legislators. What if they frame a law which is bad? The governor should be there to veto. What if they pass a law which is irrational, unfair, unjustified, unreasonable? Because we have dearth of competent legislators in India at the time of the commencement of the Constitution. There should be governor who will veto such bad legislation. That was logic number one. And second, the logic was we have just come out of colonialism and we have to keep our country united. What if there is a state which may pass a law and they will secede from the Union of India? What if there is a state which goes against the central government? What if there is a state which goes against the interest of the unity, integrity, sovereignty of this nation? For that, we need the office of governor who can keep a check on that state so that the country stays united, so that the territorial integrity of the country stays united, so that any bill which goes against national interest, that bill is stopped by the governor because governor will safeguard the Constitution of India. But there are others who say, now we have crossed that time. This may have been valid reason, justification in 1950, but not in 2020, not in 2021, and that is why it is time that the office of governor should be abolished. These are the people who say, if the job of the governor is to appoint a chief minister, that's only a ceremonial job. Can we not give this task to the Chief Justice of the concerned High Court? Let the Chief Justice of the concerned High Court appoint the chief minister. And the real power, since they are the chief minister, why create a conflict by having the governor? To summarize, here's the governor. The governor plays dual role: constitutional head of the state, constitutional link between the center and the state. But while performing this role, there are allegations that the governor is the agent of the center in the state, and it goes against federalism. In choosing a chief minister, the governor is partisan. In dismissing a chief minister, the governor is partisan. In dissolving a legislative assembly, the governor is partisan. In testing the majority, the governor plays a partisan role. In reserving the bills for the consideration of the president, the governor plays a partisan role, and it goes against federal principles. So look at this paragraph. Would it not be better, for example, to clearly specify the rules governing government formation in the Constitution itself and reduce the swearing in to a purely ceremonial action to be performed by the Chief Justice of the relevant High Court, so that we don't need the office of governor at all? But now let's look at the final argument. The office of governor should not be abolished, but the manner in which the office of governor is performing in India, it is against the principles of federalism and it violates the trust of the people in democratic politics. For that, we need reforms. What are these reforms? Number one, we have to ensure that the Sarkaria Commission recommendations are followed. Sarkaria Commission recommendations are accepted. That means these provisions must be incorporated. The governor should be provided security of tenure as well. And on top of that, we need to clarify and codify which are these discretionary powers. That means we won't go into both these extremes. Office of governor should be abolished? No. Office of governor should continue the way it is? No. We will have to follow a middle path. And what is that? Reform. Sarkaria Commission recommendations should be followed, accepted. Discretionary powers of the governor should be codified. What exactly are your discretionary powers? Codify that in the Constitution. And the bigger problem that we have been seeing, that governor is misusing his discretionary power in choosing a chief minister, something that we witnessed in Karnataka, in Goa, in Manipur, and we may witness over a period of time. For that, we have to eradicate the discretionary power of the governor here. And for that, we need amendments. Amendments in the Constitution itself. That the governor should follow these steps in choosing a chief minister. Step number 1. The party which has won the election, the leader of that party be appointed as the chief minister. Problem solved, no confusion. But if there is a hung assembly, no political party is in a position to form the government on its own. What should we do here? The first preference of the governor should be the alliance of parties that was formed prior to the elections. That means prior to elections, two political parties have come together to contest the elections together. If together they have the majority, first preference should be given to them. Clear? If they are not in a position to form the government, then the single largest party should be in a position to form the government. The leader of the single largest party should be invited to form the government, even if this political party has the support of independents as well. Which means elections are over. The party which has won the election, the leader of that political party should be appointed as the chief minister. Why? Because we don't want the misuse of the discretionary powers of the governor, because the governors have misused these provisions, abused these provisions. The party which has won the election, the leader of this party be appointed as the chief minister. If that is not the case, a pre-poll alliance. Political parties before the elections, they have decided to come together to contest the elections together. This pre-poll alliance should be given the first preference to form the government. If they're not in a position to form the government, then comes second preference, the single largest party which is taking claim to form the government. If that is also not possible, then a post-poll alliance. For example, Maharashtra. No political party was in a position to form the government in 2019 elections. Okay? Pre-poll alliance was Shiv Sena and the BJP. If they refuse to form the government, then invite BJP, which is the single largest party. If even then they're not in a position to form the government, invite a post-electoral coalition of parties, which is Shiv Sena, NCP, and the Congress. Even if this combination is not possible, then fourth option. Post-poll alliance. After the elections, few political parties coming together to form the government, and some political parties supporting this government. Not joining this government, supporting this government from outside. This preference, if it is followed, ultimately will go a long way in depoliticizing the office of governor. It will ensure that the office of governor is not misused, abused. The discretionary powers of the governor are not misused. And that is what you need to understand from the office of governor, and state machinery chapter is over. But one last point, maybe this is something that some of you may not be in a position to understand. I will explain it simply again. Post-poll alliance, let's say for example Shiv Sena and NCP, they decided to form the government. Hypothetical situation. Shiv Sena, NCP, they decided to form the government. Congress is saying we will not join the government, that means we won't be ministers, but we will support this government from outside. That means tomorrow if there is a vote of no confidence, we will vote against that. That means we will not vote in favor of BJP, we will vote in favor of you, you will continue to be in the government, but we will not join the government. That is what is mentioned in this. A post-electoral alliance of parties, with some of the parties in the alliance forming the government, and the remaining parties, which may be independents as well, supporting the government from outside. And that completes our chapter, state machinery.
Hello everyone and welcome back to Polity Current Affairs, Pardoning Powers of the Governors. Now the context of this topic is that the centre informed the Supreme Court that the Governor of Tamil Nadu would be taking their decision on the release of 7 convicts who have been languishing in the jail for over 20 years in the Rajiv Gandhi assassination case. Now the story starts from 2015 when one of the convicts, A.G. Perarivalan, had actually moved Operation Mercy Plea of sorts, seeking the governor's pardon in the particular case. Now, in 2018, finally, Supreme Court had asked the Tamil Nadu government to take some action on either accepting the mercy plea or rejecting the mercy plea. Now, Tamil Nadu government in 2018 actually recommended to the governor to release these 7 convicts, pardon the convicts. But the governor returned the file for reconsideration. Now, when the advice was sent back, the government sent back the advice again. It advised the governor again to pardon the prisoners. Now, since that time, the governor has not taken any decision. Now, ideally, the advice of the cabinet at the state level is binding on the government. Ideally, it is not mentioned in the constitution. Unlike Article 74, which clearly mentions that the advice is binding. This change was made in 1976 to make the advice of the Council of Ministers binding on the President. A similar clause, a similar provision does not exist at the state level in the parliamentary setup. We know very well that the real head of the government is the one who runs effectively the state. So it is assumed that whatever advice is given by the Council of Ministers is and should be binding on the particular governor. But since it is not mentioned anywhere, and also this fact that in what time should the governor take a decision creates a lacuna, a loophole of sorts. So this is what has happened in the case. But then the centre has also informed the Supreme Court that the governor will take a decision on this particular matter, and rightfully so. Everybody has a right to live as a good citizen, and obviously we will only be upholding the high values of our Constitution, the concept of reformative justice. When somebody is sent to prison, the idea is not so much to punish the person, but to ensure that the person is reformed. And after a long period of time, let's say the case of A.G. Perarivalan, who was 19 years old at the time of the commitment of the crime, the assassination of Rajiv Gandhi, and since then has studied in the prison, has received his BA degree, MA degree, has taken diplomas, and has undergone various certification courses, is also gold medalist. Now, even the parole board had recommended that this person has behaved decently in the prison, and he has reformed himself. So he deserves at least this, that the purpose of the imprisonment is now fulfilled. The person has reformed himself. Who are we to judge that this person is no longer fit to be a part of a civilized society just because he committed a crime, say 20 years back? Everybody should be given a chance to reform themselves. So along these lines, the Tamil Nadu government, whether it was the DMK government or the AIADMK government, both of them are on board on this particular point that this person and these convicts should now be released. But then this would act as an impediment in the investigation process. How? What CBI has tried to put forward is this idea that way back in 1998, there was a body which was formed, Multidisciplinary Monitoring Agency, MDMA. This was a CBI-led body, Multidisciplinary Monitoring Agency, and the task given to this body was to find out the larger conspiracy behind the assassination. CBI had believed that this assassination was not just a one-off case, there was a larger conspiracy behind this assassination, and this MDMA was looking into this particular larger conspiracy only. However, more than 20 years have elapsed, but CBI has not furnished any report to the Supreme Court. Supreme Court has also said that this is just one loophole which the CBI is trying to use when they say that if we release the convicts, we may not be able to perform the investigation properly effectively. Had you shown some intention, you would have furnished reports, information, presented data on various aspects of the investigation, but you have nothing to show as of now, and you are holding the life of these people just because there is some hope You believe that a larger conspiracy prevails. And that's not how governments function, based on the whims and fancies of some officials. That is why it is imperative, considering humanity, considering the high ideals of our constitution, including Article 21, that we should give every possible opportunity to people to perform themselves. So this should be released. But this is not something which is of great importance for our examination. What is important is the backdrop. Just to point out this fact, what has been the reason for the delay? As I mentioned, the governor has not taken any decision. And in fact, last year, Madras High Court was so dejected at the governor that it went on and said that yes, we agree that there is no time limit mentioned for you to give your judgment or for you to give your decision. But if you do not take any action, we will have to intervene and take action on your behalf. The constitution does not specify within what time frame should the governor, should the president give his assent. It's not mentioned. Why? Because faith and trust is attached to these constitution posts. If you do not follow these basic tenets, the faith and trust clause that is attached to these high functionaries posts, then the particular constitution falls flat. We will not be able to administer the country properly. So if you delay too much, we will interfere and take a decision on your behalf. So first aspect of this particular topic is the concept of the governor. Now some people are also raising the question, just like Article 74, should we also make the advice of the Council of Ministers headed by the Chief Minister binding on the governor? The provisions of Article 163 should also be binding. If not, it can always happen that the governor will act as a tool of the center in the states and will always follow what the center has to say. This can also devoid the people of a rightfully elected government which is equally powerful, because eventually if the governor starts misbehaving in this fashion, deliberately withholding assent even in important matters, then the functioning will come to a halt. The administrative engine will automatically come to a halt. That's the question number one, which we have to consider. Second is the mercy power or the pardoning power of the governor. Now, Article 161. There is an Article 72 which provides for the pardoning powers of the Indian president. Similarly, there is an Article 161 which provides for the pardoning powers of the governor. So, as per Article 161, the Constitution grants the power to the governor to grant pardons, reprieves, respite, remission, or to suspend, remit, or commute sentence of any person. There is a catch. Governor cannot pardon a death sentence. President can. So, if suppose, or let's say somebody else having a death sentence, the governor cannot pardon the death sentence. Apart from it, the governors cannot use the pardoning powers in case of court martials. What is court martial? Court martial means military court. So only the president can pardon the decisions, the punishments given by court martials. Only the president and not the governors. These are two differences. Number one, the governor cannot pardon a death sentence. Number two, the governor cannot pardon a punishment given by a court martial or a military court. Now coming to what these terms mean. First things first, pardon. What is pardon? Complete removal of the punishment and letting go a person free. You are absolved of all the guilt. You are free to go. Now, as I said, if you have been given a death sentence, normally if you have been given a death sentence, you are not pardoned directly. That's not done. When a person is given a capital punishment, what is done is your sentence is commuted. What is commutation? Changing the type of punishment, the nature of punishment, the character of punishment is changed. So if you are given a death sentence, it will be modified into say a life imprisonment or 14 years in jail. Now this is a punishment of a different character. You are being imprisoned, not being killed. That's the difference. So ideally, all death sentences are commuted. And let's come to the real catch here. A president can pardon the death sentence. Governor cannot. But what if there's a person who had been given a death sentence after the person applied for a mercy? This death sentence was commuted to a life imprisonment. Say 20 years in jail. Ideally, life imprisonment means till the natural end of your life. But let's say after 12, 14 years, the person's behavior has been very good in the prison. Now can the governor pardon this person? Yes, he can. Why? Because now this person is undergoing an imprisonment, not death sentence. So indirectly, a death sentence can be pardoned, not directly. Meaning, first step is you commute the death sentence to life imprisonment or any kind of imprisonment, and then you now can pardon the particular person's imprisonment, the punishment. This can be the governor. That is why sometimes in newspapers you read the governor has pardoned the death row convict. He has not pardoned the death row convict. No, the death row convict's punishment has been commuted to a life imprisonment, or say 14 years in jail, or 20 years in jail. The governor has pardoned this life imprisonment and not the original death sentence, because a death sentence cannot be pardoned by the governor. Yes, the president has the power to directly absolve this person of all the guilt. Say you are given a death sentence, tomorrow the president signs on the mercy petition, you are free to go. No punishment, nothing. All charges removed. You are absolved of all the guilt. That's pardon. Then the accommodation where the character is changed. Then there is remission where the character is not changed, but the period of sentence is reduced. Say you have been given life imprisonment. You feel it's too harsh. I did not commit this crime, but maybe there were circumstances, there were mitigating circumstances, or I committed a crime by mistake. Now I realize my folly. Right? The classic example of Shawshank Redemption. So if you have been given life imprisonment, say after 15, 20 years, the governor, the president can issue an order of remission, and this can be changed, say to 10 years, 20 years, whatnot. So you can also apply for remission, where the period of sentence is reduced. Now this is not applicable in case of death sentence. There is no lesser death. Either you die or you don't die. So basically remission is applicable only in cases of imprisonment. Then respite. You have seen this a lot many times. How? You know, where all these hotshot politicians, big corporate industrialists, celebrities, as and when they are put behind bars, suddenly their BP rise, their blood sugar comes down. They start having all these health issues which were not there when they were canvassing, when they're campaigning. So what happens? They are taken to some hospital and they're kept there. Now that's not a part of punishment. That's very lenient punishment. You being put in prison, judicial custody, you being put in hospitals, that's entirely different circumstances. What is this? This is what is called respite. You are awarding a lesser sentence, lesser in the sense of harshness, lesser sentence because of some special circumstance. Meaning, let's say a person becomes ill in jail or because of COVID, let's say a pregnant woman, let's say you contract TB, pneumonia, whatnot. In this circumstance, you may not be able to go through your punishment. So you are awarded a lenient sentence, a less harsh sentence under some special circumstance. This was primarily applicable earlier when we had a concept of simple imprisonment and rigorous imprisonment. What is rigorous? You know, back in 1960s and 70s, you saw these movies where the prisoners were taking stones, splitting roads. That was called rigorous imprisonment. Other prisoners who were on a simple sentence, they were in the jail, they cook food, clean the premises, that's casual punishment. This was rigorous imprisonment. Now it's no longer there. We don't ask the prisoners to build roads. So this concept has gone away. But what has now come to light is that whenever any person is in the prison, if he is sick, if she is not well, they are taken to the hospital, and for the entire duration, order of respite is approved by the governor. That's how it is done. Now coming to the last one, that is reprieve. What is reprieve? Suppose the Supreme Court has given death sentence to a particular prisoner and has scheduled that this person, the execution of the particular sentence will take place, let's say on 25th of January. Let's assume today is 10th of January. The punishment has been given. Now this person has an option, can file a mercy petition with the president. Sir, please don't kill me. I'll improve myself. First, they give me a prison sentence, a jail sentence, imprisonment. Now this person will file a mercy plea. The letter will be sent to the president's office. Please understand that with the very fast speed of Indian Post, the president may not receive the letter in 14 days. It is possible. Thus, when the president receives the letter, can he or she put aside every other aspect and jump into deciding this matter only? There are other aspects as well.
he or she has some other roles and responsibilities that need to be taken care of. You cannot simply leave everything aside and take care of this aspect only. That's blatantly foolish, to say the least. Plus, this power of mercy, let's be very clear, is not the power of the president or the governor. This power is of the cabinet, the government. Under the advice of Council of Ministers is this power used. So, do you think the Minister of Home Affairs will keep everything aside and look into the entire matter, all the aspects? That's not possible in this very short time frame. And by 25th January, the person has to give. Then what is the point of this mercy petition? So what happens is, firstly, apply for a reprieve, meaning you ask for a temporary stay on the execution of the punishment. That's what. Please don't think right now. Wait for the president or the governor to decide on a mercy petition. So this is what is most commonly used. Number one, you file for a reprieve. Stay order. Don't execute the punishment right now. If you kill me, how will I use the mercy petition? So first things first, reprieve. With reprieve, you file for a mercy petition. Now, depending on your circumstance, you can be pardoned, commuted, whatever. So these are the various orders which come under mercy petition. Couple of things that you have to keep in mind before you move on to mercy petition. Number one, as I said, mercy petition or the pardoning power is not the power of the governor or the president. It is to be exercised on the advice of Council of Ministers. First, secondly, the petitioner, the prisoner, has no right to oral hearing. Don't expect that this will happen, that the prisoner will go to the president and start crying, sir, please forgive me, this was a mistake, I won't repeat it again. This is not allowed. You are in the prison. Through a letter, the matter is sent to the president, who then takes it to the Home Ministry, which looks into the aspect of the matter and then advises the president, the governor, on the same. So, very important are these two things, that it is a power of the Council of Ministers. And secondly, the petitioner has no right to oral hearing. And Supreme Court has issued guidelines saying that please do not misuse this power. This power should not be used in random cases for politically motivated circumstances. This power should not be used randomly for along the caste lines. This power is a very unique power. And this is beyond the scope of judiciary. This is not a judicial power. It is not as if you are going and challenging the Supreme Court's judgment. No, you are not. What you are simply doing is asking the president, the governor, sir, Supreme Court has punished me. Can you show some mercy on me? I'm not here to question the judgment of the Supreme Court. I'm simply seeking mercy. So this is not a judicial power. This is beyond the scope of judiciary. When the judicial journey of the case is over, that is why you seek mercy, seek a pardon. Okay, let's see a sample question. Which of the following statements are correct? Number one, pardoning power of the governor is his or her discretionary power. Number two, governor can pardon death sentence prescribed under state law. Coming to statement number one, this is incorrect. As I said, it is not his or her discretionary power. It is always on the advice of Council of Ministers. Number two, governor can pardon a death sentence prescribed under state law. Governor cannot pardon a death sentence. That's the real difference. Governor can commute a death sentence. Cannot pardon it. So both one and two are wrong. The right answer for this question is D. Neither one nor two. That's all for this topic. Thank you.